So we are here today to talk about a very timely subject, and for those of you who know me, I'm all about everything that's timely and what's in the news lately. And just this past Tuesday, we had the new rules for HIPAA coming out, and now everybody needs to be compliant. Everybody in this room needs to be compliant with those HIPAA rules, whether you're a service provider or a healthcare provider. So we bring in the best of the best here at MOROF, and that is why Keith Carrington is here. Keith is the compliance officer for Comtech City, and he does this for physicians, practice administrators, hospital administrators. It runs the gamut. He tells you in this huge book whether or not you are compliant. So take it away, Keith. Keith, by the way, I have to add this because it's so interesting. He's months away from being a lawyer in healthcare and also getting his PhD in health services. So smart man, right? Take it away.
Thanks, Michelle. Well, good morning. Can everybody hear me okay? Excellent. I got the yes, sir. I'm in trouble already. Michelle, thanks for that introduction. Normally when I walk into a group of doctors and introduce myself as a future lawyer, I usually get knives and tomatoes thrown at me, so thank you for this morning. I usually like to get started by finding out who I'm talking to today. So by a show of hands, how many physicians do we have in the room this morning? Okay, we've got a few. How many practice administrators or office managers, also known as the brains of the operation? All right, we've got a few of those. And how many vendors do we have in the room this morning? Okay. Anybody whose hand has not gone up? I'm sorry, this is not the timeshare presentation, so you may want to check down the hall for that one. If, however, you did raise your hand to any of those three questions that I asked this morning, then now you're certainly in the right room this morning. 58 hours ago, or actually 56 hours ago if I did my math right, the new Omnibus rules took effect for HIPAA. And if you've been following either the news out of Health and Human Services about this or any of the other coverage so far in the last 2 months since these rules were published in the Federal Register, you know that Health and Human Services is quite pleased with what they've rolled out. You may not all be, but they certainly are. And you also know that they're taking it very seriously. And so over the course of the next hour today, we're going to take a look at what the Omnibus rules are. And, you know, Omnibus is nothing more than a fancy word for a collection of rules. And in this case, the Omnibus rule actually has 4 rules that impact HIPAA. So we're going to talk about those today, and we're going to specifically focus on the provisions that impact providers, so the bulk of those in the room today. We're also going to talk about business associates. So those vendors in the room who may come in contact with or have need to touch, handle, store, transmit protected health information, then you too are now going to be directly liable starting September 23rd. And then we're going to finally close out this presentation with a brief discussion on what steps you should take in the next 178 days to meet the compliance deadline of September 23rd. Now, I typically get asked, why? Why do we need to know about this? Why is the federal government passing this down? And why is this important for my practice? Many healthcare providers I talk to equate compliance with, great, more money I've got to spend on something else that I really don't either have the money for or want to necessarily spend the money for. I also frequently get the comment that, you know what, there's over 230,000 medical practices in this country. How likely am I to get audited? What's the likelihood that I'm going to have a problem, or what's the likelihood that I'm going to incur a breach? Well, the reality is that breaches occur every day, and there's absolutely no way we can guarantee they won't occur. Breaches have happened. They continue to happen on a weekly basis. We hear new reports of breaches, and they're going to continue to happen. And if any of you have risk managers, compliance officers, or you talk to your insurance providers, they're going to tell you the same thing. You can mitigate risk, but you can't ever resolve all risk or eliminate all risk. You're not going to get a risk score of 0. It just doesn't happen, not when there's the human condition and humans are in your practice working it every day. So that's certainly one reason. The second reason, though, that I think it's important and timely that we focus on this today was a comment that caught my attention earlier this year from the Office of Civil Rights Director, Leon Rodriguez. He stated in a press release that was put out the week before the Omnibus rule was published in the Federal Register, and he had stated that these changes, referring to the Omnibus rule, not only strengthen the ability of his office to vigorously enforce the HIPAA privacy and security protections regardless of whether that information is being held by a health plan, a healthcare provider, or their business associates. What this is interesting for those of us who study policies, study the law, and practice it, we take a look at this, and what we're noticing is that the rhetoric has shifted within Health and Human Services. How they're communicating these rules and the statements that they're making like this clearly give us an indication that we know there's going to be stepped up enforcements. Just last week, the same Director Rodriguez, indicated that they will be making permanent the random HIPAA audits and that they will be commencing with round 2 of those later this year and increasing the number of HIPAA audits that they do that are random to a practice. So it's important that we understand what changes are coming and what's required of the practice, if nothing else, to go ahead and remain compliant so that if you are targeted with a random audit, you know what to do, you will be able to pass that audit. And if there are issues, hopefully they're very minor issues that you can work with Health and Human Services on to resolve. But there's another reason why these rules get implemented, and there's another reason why we need to take concern or take heed with them. And that is that what we do in healthcare every day impacts the lives of the patients we serve. And not every impact is dealt with at the point of care, nor is it resolved by the care. Think about this. When your patients walk into your offices, they're giving you their credit card. They're giving you their address, their name, their date of birth. All of that's now getting stored, hopefully electronically in an electronic health record system. But regardless, it's being stored. If that information is breached, it's going to have a tremendous impact on those patients. More importantly, it will have a tremendous impact on you. We live in a very litigious society, hence why we see the proliferation of attorneys. But we also live in a state that leads the nation in numbers of lawsuits being filed and in the number of regulatory complaints that the consumers pass on. Think about the last time you were wronged, whether it was maybe your identity was stolen, maybe something was taken from you, or maybe you just had a service provider who couldn't fix your laundry machine properly. What steps did you take to try to resolve that? Did you work with them? If they were uncooperative, what was the next step? Do you file a complaint with the state? Do you go to the Better Business Bureau? Chances are you escalate that resolution until you get satisfactory resolution, whatever that may look like. Your patients will do the same thing. If their data is breached, they may not call you first and say, "Dear doctor, I'm upset about this. How are we going to fix it?" They will either call an attorney, they will call the state, or they will call the federal government. That's what they've been conditioned to do, and it's what they do very well. When that happens, not only do you run the risk of the regulatory compliance actions being taken, but you also run the risk of litigation. And that litigation, when compounded as class action, if you had a breach of, say, 50,000, and you have an attorney who wants to start collecting up all of the individuals who were harmed, then now you're facing an even more daunting task. And I dare say that everybody in this room, whether you are a physician or you're a business owner for a vendor, or you're a practice administrator or office manager who has put blood, sweat, and tears into building a business, building that practice, you don't want to risk it unnecessarily. So hopefully what you're going to get out of today's presentation will certainly give you some fuel and some information that you can take back into your practice or into your business and work towards getting compliant to mitigate that risk so that you decrease the chances of any adverse effect being taken against your practice, whether it's from a regulator or it's from that end patient. As we go through the presentation today, the first thing we want to do is identify the rules that comprise the Omnibus rule. And there are 4 of them, as I had stated. We are actually going to focus on the first 3 that are on this screen. And I do want to point out, by the way, that if you're having trouble seeing the screen, copies of the presentation are on the table so you can follow along with it. And then I forgot to mention at the very beginning, this video presentation will be online at the MOROF website within the next week or so. And we'll let everybody know once it goes on there so you can reference back to it. Okay. The first rule that's included in the Omnibus rule is the modification to HIPAA's privacy, security, and enforcement rules, and we're going to dive into that here in a few minutes. We also have the implementation of the tiered penalty systems that first came out in the HITECH Act of 2009. Nothing new here. We just kept the same policies or the penalty tiers that we've seen since 2009. But if you remember, in the HITECH Act, it was going to have to be codified, and it would have to be made permanent, and that's what this rule does. We have modifications to the interim final rule for breach notifications. And this is one of the areas where there's going to be a big shift because we change how we define a breach and what the requirement is for that. So there's some burden shifting, and unfortunately that burden shift falls squarely now onto the practice or onto the business associate. And we're going to see how that works here in a little bit. And then the last rule basically implements Section 105 of the Genetic Information Non-Discrimination Act, or GINA. And this really applies to healthcare insurance companies, healthcare payers, who are now prohibited from using genetic information for underwriting purposes. If this is something that is of interest to you or it may impact you in some way, please feel free to see me after this presentation or give me your card. I'll follow up with you later if you want more information on that. But it just doesn't really apply. We don't have a lot of time to go into that today, so I'm going to skip over that if everybody's okay with that. Before I go into it, though, I do want to give the legal disclaimer. As Michelle said, I'm about 8 months away from having my law degree, which means I am not yet a lawyer. So please, nothing contained in this presentation this morning should in any way be construed as legal advice. I suggest if you have specific legal issues, you direct those to your attorney. If you don't yet have an attorney, particularly a board-certified health lawyer, here in Florida, let me know. I work with a number of them. I'll be happy to give you some recommendations or a list of lawyers if you need to contact them and screen them. When we get into taking questions today, I would also state that as I've done these presentations for a while now, I find there are two types of questions, those that pertain specifically to a particular practice and more generalized questions. I'll be sticking around afterwards. I'll be happy to answer specific questions about your practice. I don't necessarily want to invite you to have to share that for the whole room, but also understand that if I do answer those questions for you, don't get frustrated if I have to push you to an attorney, because there's a fine line and I can't cross that line, okay? So with that said, let's start off by talking about covered entities. So for the physicians and the office managers in the room, this is where you may be most interested, and for our business associates, refill your coffee, get some more to eat, sit back, relax, and I'll be back with you guys here in a few minutes. There are a number of provisions that affect them, everything ranging from updated civil monetary penalties right down to school disclosures and everything in between, and we're going to take a look at each one of those. So getting started, let's talk about those civil monetary penalties. The provisions here, as I had indicated, really kept the high-tech provisions in place, but we got more clarity from Health and Human Services, particularly around how we set fines. So if you remember, HIPAA fines can range, and there is a very broad range, $100 up to $250,000, $500,000 in compounding, up to $1.5 million in a calendar year for the same or similar offense. So how is it that we get it? You know, and that's a big question both for physicians as well as their attorneys, is trying to figure out what does Health and Human Services and what does the Secretary use in order to determine if they're going to impose fines, what those fines need to be. So we actually updated the factors that they're going to be used in weighing the situation. We also will be focusing moving forward on the violator's knowledge and willfulness. So if you remember when HIPAA first came out, and really up until this point, there has been equal attention given to you should have known about this, but there was no willful misconduct in terms of the breach. And we're going to really see the enforcement stepped up is taking a look at those willful breaches. And so there is some good news for physicians if there's some to be found, in that, you know, the focus is going to shift at least somewhat. They also announced 2 tests. And in the legal realm, we judge everything by a test. We'll test a situation, and that will tell us how we're going to go ahead and resolve that issue. Well, here we have 2 tests. Both are known as nature and event tests, or extent, rather. We take a look at both the violation, the nature and extent of that violation, as well as the harm that results from that. Obviously, the less harm, if PHI wasn't actually ever breached, well, then you know what? It's going to be a less offense, as opposed to 50,000 records on a laptop were stolen and 50,000 credit cards were opened, one in each of the patient's names. Then we have an issue. And then the penalty amounts set forth were again unchanged, as we discussed. So let's take a quick look at the extent of the violation. Health and Human Services will be looking at the number of individuals affected. So obviously, if we have a PHI breach affecting 1 record, then that's far less severe than 50 records or 5,000 records or 100,000 records. We also take a look at the time period with which the violation occurred. Was this a single event? Was this the story that we heard just last summer of an office manager who took a laptop home that had clinical research data on it, unsecured protected health information on it, and she ran to her gym to pay her dues for the month, then ran to Walgreens to pick up the prescription for her sick child that was called in earlier in the day on her way home. She left her car unlocked, and somewhere between the gym and Walgreens and the house, the laptop was stolen. She doesn't know where, and 50,000 records were breached. And unfortunately, of that, 138 patients reported identity theft that they have been able to tie back to that. So again, if we think about it, not only is that practice incurring the civil penalties that are going to attach, but they now face 138 lawsuits for failing to protect that. So they will certainly be looking at that. The time period is important as well because obviously the fines and the penalties will increase if it's been an ongoing breach. If we take a look at incidents such as the case here in Central Florida with a hospital that I shall not name, where they had an employee who for a period of time was actually taking patient data from the emergency department and trying to sell that to attorneys and chiropractors. And that occurred over a period of time as opposed to a single incident. So there again, what Health and Human Services is going to look at is say, what kind of protocols do you have in place in your practice to identify when a breach occurs and then to stop it as quickly as possible, not let it occur so that we have that compounding effect on multiple breaches occurring over a period of time. We also take a look at the nature and extent of the resulting harm. And what's going to happen here is they're going to take a look and say, was there actual harm caused by this breach, or was it innocuous? Was it prevented in time? So they're going to look and see, did this violation cause physical, financial, or reputational harm? Certainly in the case of the office manager, where 138 records were used to open up false credit, buy boats, take out a mortgage, those kinds of things, there certainly was physical, financial, and possibly reputational harm, in which case fines will be greater. When we take a look at whether the violation hindered the individual's ability to obtain health care, we'll also take a look at the history of prior compliance. Has this practice had issues in the past? If they have, then you can expect a much stiffer penalty for repeat violators moving forward. And then we're going to take a look at the financial condition of the covered entity or the business associate. And they're not looking at this from the point of view of, hey, how rich are you? How profitable is your practice or your business so that I can up the fines and get more money from you? Whereas if you're a startup, you're poor, you're heavily leveraged on debt, you know what, we're not going to charge you as much. That's not what they're saying here. What they're looking at, we'll cover this when we get to risk assessments at the very end of our presentation. But what they are looking for is, have you taken all the appropriate steps and measures within your business commensurate with the size and the financial abilities of your practice? For example, when we assess risk in a healthcare setting, I will walk into a medical practice and I will look at the risks of that practice based on its size. I don't assess risk the same way I do for a one provider practice as I do a 60 provider specialty practice, because the 60 provider specialty practice has greater financial resources at its disposal and the risk is greater. We have 60 times the providers. We have a larger amount of patients. So one, the risk is greater, but two, so are the resources to bear to mitigate those risks. It also comes down to this, and I tell this to all of my clients when doing a risk assessment. If the risk exposes you to a $100 liability and it takes $5 to cure that risk, the expectation is you're going to spend the $5 to cure the risk and not incur the $100 penalty. And that's what they're looking for here. If this is a low dollar threshold, one that you could easily afford, then you should have taken it, and if you didn't, you can expect higher fines. Likewise, if it exposes you to a $100 risk or a $100 fine, but it's going to cost you $10,000 to mitigate this risk, it doesn't make financial sense. And believe it or not, the federal government has figured out that there needs to be some common sense in things that they do. And what they've gone ahead and done is said, hey, guess what? We'll actually let you cost justify some of your actions. So again, they're not going to penalize you in the same way. Obviously, if you have a breach, they will, but they are going to be taking a look and saying, was this something that could have been mitigated? And if it couldn't, did you at least have sufficient workarounds, or was there sufficient monitoring for it? And that's the key here. So understand those are the two tests that we're going to use as we try to balance out and determine what kind of fines need to be levied. There are some affirmative defenses that both business associates and the healthcare providers can exert in situations, but whether or not you can use those affirmative defenses against the regulatory action is a very case-specific process, and it is one best left to your attorneys to go ahead and define for you. So I am not going to go into specific details other than to let you know that they've modified the old affirmative defenses that were available. They apply both to covered entities as well as to the business associates in this room today. And they are for violations occurring after February 18th of 2009. So if you have a violation that actually occurred and was triggered before February 18th, the new affirmative defenses will not apply. And again, your legal counsel can walk you through that far better than I could in the limited time this morning. If you remember, I told you that there were some changes to the breach notification requirements, and this is where we do see a lot of groaning on healthcare providers, and I certainly understand why. Prior to the Omnibus rule taking effect 2 days ago, the rule is that there was a harm threshold. And it stated that it was a breach only if it posed a significant risk of financial, reputational, or other harm to the individual. So it gave you some leeway in there to determine whether or not, do I need to report this breach or not? Well, that shifted. You don't get to make that determination anymore. The federal government says every breach is a breach for purposes of notification. You now need to go back and justify why it is not, and you need to do that through a risk assessment. So the kind of letting you make the call up front has been removed, and it's been replaced with the presumption of a breach, which this will, what this means, in other words, is that we are going to see increased risk or breach reporting occurring starting on the compliance date. Between now and September 23rd, we still operate under the old breach or the interim rule, which states if you can justify that there is no harm or there's not a significant risk of harm, then it may not be a breach. And again, that's a determination you make in concert with your compliance and security officer team and with your attorney before you make it. The challenge starting September 23rd will be that no, you have to assume you're going to be reporting that breach, conduct a risk assessment. Based on the findings of that risk assessment, then that will tell you whether or not you need to report that breach. So if we take a look at that, there are a couple of ways that we can negate that breach presumption, right? And this applies to both covered entities and business associates. So business associates, if you're still finishing up that second cup of coffee I told you to get, you might want to perk up just for a minute here. There is you have to demonstrate through your risk assessment that there's a low probability that the protected health information has been compromised based on a set of 4 criteria, and that is the nature and extent of the protected health information involved, including the types of identifiers and the likelihood of re-identification. If you have an Excel spreadsheet and it's got the patient's name, patient address, patient date of birth, and it's not encrypted, and they're all in the same worksheet, in the same workbook of Excel, chances are there's a real high likelihood that that's going to be re-identified very easily. Simply open up and read the Excel. However, if you've got multiple databases that are querying each other and you've got one segmented here, perhaps on a server that's not even on there where you've got name, address, date of birth, but then you've got assign a clinical identifier number, and in the data on the laptop, you only refer to that identifier number and then whatever other pertinent data is there. Well, then obviously the likelihood of re-identification may be less. So that's one area that we would be looking at in that risk assessment. We're also going to look to the unauthorized person who used the protected health information or who that disclosure was made. Why? How did it happen? Again, human error. I'm mailing out x-ray results for patients, and I put patient A's results in patient B's envelopes and mail it so that patients A and B get each other's x-ray reports, and it's human error. That's going to be looked at very differently from the risk assessment standpoint, as opposed to I'm disgruntled because I asked my boss for a pay raise, was laughed at and told no, and I get upset. So I go back and I go, really? Well, I'm going to go take this data and I'm going to sell it because Daddy wants a new car. Well, If that's the case, then obviously there's a greater risk involved. So we are going to be taking a look at the individuals involved in that breach and what were the intended circumstances around that. We're also going to be looking at whether the protected health information was actually acquired or viewed. Again, if this laptop gets stolen and it has protected health information on it, and I have the program on it that allows me to remote wipe it, so I can instantly delete all the data, and I did that, then guess what? Chances are data wasn't viewed. If I know, I come out of Walgreens and I look in the backseat of my car and know that sometime in the last 20 minutes this laptop was stolen, and I, through my iPhone, go and I wipe it, or I call the office and have them wipe it, and it's wiped, then chances are data wasn't done. If I don't have those abilities, and you know what, my risk assessment says I probably should, and I ignored that, and I don't have those kind of safeguards, which, by the way, costs about as cheap as $35, and you don't have that capability, and you don't wipe it, and 4 days goes by before the police find the laptop, and chances are it was accessed, and they can see that it was accessed afterwards, then you've got a problem, and you need to notify for that breach. You are also going to look at the extent to which the risk was protected health information has been mitigated. What steps have you taken outside of that? Have you already contacted those patients? Have you offered credit monitoring and identity theft monitoring services for them? What other steps are you taking? Have you gone ahead and reassigned new data? Have you moved, perhaps again, if we go back to database with PHI, have you moved it? Have you put new passwords? Did you re-secure it? Did you change everybody's passwords if you had an employee that did a breach? So they are going to be looking at the other steps. Once we go through those 4 criteria, we'll have a better picture and a risk score for that breach. And that's what's going to end up guiding you in making that determination of if you have to breach. But as you can see, it's far more intensive than the prior test was, which really was a shoot from your hip, make a determination call on what's the likelihood of harm. Well, I don't think it's very likely, so we're not going to breach it. And then everybody would cross their fingers and hope that nobody actually reports it to the government, and they come walking in and go, why didn't you report it? Because then you have to justify that determination. Now you actually have to go through a very formal process. Let's also take a look at the example. Here's an example of a situation which under the old interim rule was not deemed a breach, but now would be. And the situation is this, that you have a non-permitted use or disclosure of de-identified information that does not include date of birth or zip code. It wasn't a breach before. Now it would be subject to the default presumption of a breach, and you need to go through that risk assessment. So again, keep in mind, they're going to get far stricter. They want these breaches reported, and they want you to go through a more formalized process of assessing that, and doing so fairly quickly after you've learned about it. So the next provision, which may or may not be of much interest to you at this point in time, regards the sale and use of PHI for marketing purposes. And it's a fairly lengthy section, so we're going to try to carve it down here fairly easily for you. First and foremost, you are prohibited from selling PHI information without receiving proper authorization prior from the patient to sell the data. So if for whatever reason you're going to be selling a subset of patient data, clinical data you have on them, if it includes PHI, you have to get their authorization, and that authorization must state that the covered entity will receive remuneration for the disclosure. This rule also narrows the definition of marketing because there are some marketing restrictions that you can do, and by narrowing it, we've actually allowed for some errors where we heard through the public comment section during the interim rule when they were developing the final rule, we heard from a lot of covered entities that they were very frustrated about such a broad, expansive, nebulous definition of marketing, and that it was grabbing in some practices that occur fairly routinely in a healthcare setting that shouldn't really be marketing. So they've gone ahead and they've narrowed it down and specifically addressed the overwhelming calls, as we'll see here in a second. So first off, how do we define sale? Well, what constitutes a sale? When you directly or indirectly receive remuneration on behalf of or from the recipient of the PHI. So if you're going to sell your patient data to another practice or to a pharmaceutical or to a research partner or to anybody that you have the opportunity to sell it to, if you are going to receive remuneration, whether it's directly from them or from a third party, either way, it still constitutes a sale and you're going to be subject to the rules. There are, however, a broad range of exempted disclosures. Again, you have that in your packet. I'm not going to read all of them this morning for you. And again, you'll see it on the presentation online as well. But some of our common suspects are there. Obviously, if you're disclosing this information or selling it for public health purposes, research purposes, treatment and payment purposes, so forth, those are going to be accepted. Do keep in mind, particularly with research, and then for other purposes that may be permitted under the privacy rule, there are some cost constraints on there that you have to play with in terms of meeting those thresholds in order to qualify for a legitimate sale. In terms of marketing, marketing does not include refill reminder communications any longer, and it does not include the communications for treatment and healthcare operation purposes. All right? There was some concern that the old definition of marketing was so vague that it could include the IVR automated patient reminder calls, or the calls by your staff calling a patient and reminding them of a visit. Those have gone away now. But the key here is that if you're doing any of these for a third party through your practice, maybe you've got a lab that's set up in your practice and your staff is going to call and remind on lab work as well, or you're going to make other calls on behalf of that lab that's set up inside of your business. If you get compensation beyond the cost of making the communication for those services, then you're going to run into the prohibitions on marketing, and there are other steps that you need to take, and I'll be happy to walk you through those. But understand this, the key is you can do these things, but if you're getting compensated from a third party for it, make sure that compensation is limited only to the cost of making those communications. If that exceeds that, then you're going to run into some problems. In terms of fundraising, you can go ahead, a covered entity, you can disclose information to a business associate or to an institutionally related foundation. All right? So again, make sure that you're vetting who you're working with for fundraising purposes, or that you may be sharing data with on fundraising purposes. You do not need a HIPAA compliant authorization to do so, provided, again, it's going to a business associate that's covered under a business associate agreement, or it's going to an institutionally related foundation. And all you are releasing to them is the Department of Service information, treating physician, outcome information, and health insurance status. Any other information than that is going to trigger a HIPAA compliant authorization beforehand. There are some other requirements in terms of fundraising. If you engage in fundraising efforts and PHI is disclosed as part of that effort, you must provide your patients with an opt-out provision. This can be done on a separate fundraising form. It can also be done in your notice of privacy practices, which we're going to talk about here in a second. But you must include an opt-out provision for fundraising. You may not cause an individual undue burden or more than a nominal cost to go ahead and opt out. Opting out by phone, opting out by email to an opt-out, checking it on the form, mailing in a letter are fine. Don't make them jump through hoops or overly costly hoops, or sending a notarized letter that they're opting out. Don't make it difficult. Don't make it costly for them. You may not condition treatment or payment, not that anybody in this room would, but again, it bears noting, the rule specifically points it out. You cannot condition treatment or payment on whether an individual's opted out of receiving fundraising communications. You may not send fundraising communications to those who have opted out. Okay, so if they opt out, I don't want to get this fundraising information, you can't send it to them. You are, however, allowed to have a patient opt back in. You can give them that option, which means every time that they come back in, or every time you're putting out your privacy practice notice, you can put an opt back in clause if you want. Before you couldn't. Now you absolutely can. Let's talk about notice of privacy practices. How many, from physicians and office managers in the room, how many of you put these out annually for your patients? Okay. A couple. Guess what? You need to be doing that on an annual basis. It needs to be mailed to them. It can also be posted prominently on your website, but it does need to make its hands to them. The assumption that if I just hand it to them when the patient comes in, well, that's great, but you're still not going to hit every patient when you put that out. And more importantly, The Omnibus rule is forcing every practice this year to go back and take a look at your notice of privacy practices. There are some changes that must occur in your notice of privacy practice. There are some new additions that need to be added to it, and as a result, it will trigger that you must send them out. Once again, you also can prominently display them on your website as well, but make sure, again, it's prominent. It's not hidden where somebody has to go hunt for it. If you're going to put it on the website, it's got to be there prominently. So what is it that you have to include on the new privacy practice notice? First, description of the types and uses of disclosures of PHI that require authorization pursuant to the privacy rule. I have a checklist. I'll be happy to send it to you. I'm also putting together with a health lawyer here in town the new template. So we'll be happy to get that template to you as well here, probably within a week. That'll all be done. So we'll happily send that out, and I know we'll make it available through the MOROF website as well. The statement of legal requirement to notify in a breach. You must have specific language in your notice of privacy practice that you are obligated by law to notify individuals of a breach of their security. You do not need to have a statement for healthcare services or benefits, IVR reminders, appointments, etc. It does not require a separate statement. It can be implied. So if you've had a separate one in the past, it does not have to be there. You do not have to go and add it. Fundraising statements, however, if you are, again, we just talked about, if you're going to run your opt-out through your NPP for fundraising, you have to go ahead and put those statements in there that the individuals have a right to opt out of receiving such communications, and then give them that opt-out on that privacy practice or on their forms when they're in with you. Okay. Again, these need to be revised as of September 23rd. So I would strongly suggest that everybody dust off your privacy practices, take a look. I dare say 80% of practices when I walk in and I do their risk assessments, I'm finding that they haven't reviewed them in a number of years. For those of you on website who have websites for your practice, I can kind of tell when you launched your website, because I still see a privacy practice dated 2002, 2003. It's time to get those updated, and keep in mind they do need to be distributed annually to your patients. And certainly that is now going to be purview of OCR if they're auditing you. They're going to be asking about those. There's also some expansion of rights for the individuals contained in the Omnibus rule as it pertains to the covered entities. First, if an individual requests information to be restricted to their health insurance provider, you must go ahead and honor that provided two conditions are met. The disclosures for the purpose of carrying out payment or healthcare operations and not otherwise required by law, and that the protected health information pertains solely to a healthcare item or service which the individual or other third party acting on their behalf has paid for in full. So again, if in your practice you have patients who have insurance but have to pay for certain things on their own, chiropractors, this is a good one for you. Oftentimes you're going to have treatment procedures that don't get covered under insurance. So that's a cash pay for them. Your patient can absolutely now request that information about those services that they're receiving from you not be shared with the insurance company, and that has to be honored now. We also have some additional provisions here regarding the electronic copies of PHI. If you have a patient who requests that they receive a copy of their medical records electronically, you need to be able to give it to them electronically, provided you store it electronically. If you're using an EHR, and they ask, I want it electronically, it needs to be emailed to me. Please send it encrypted. Don't send it through Gmail either. But by all means, you need to deliver that electronically to them. You can also, however, charge them for it. Just like we charge now for paper copies of medical records, you can charge them the cost of the media. So if they say, look, I need this electronically and it's going to get burned to a CD, you can charge them for the CD. You can charge them for the USB flash drive if you're going to give it to them on a USB flash drive. So you are able to collect that money, and keep that in mind. You can do that, but you do need to honor the request for copies of PHI, provided you store it electronically and provided it doesn't require additional software to do that. So if you've got it electronically, but it's going to require you to go out and buy new software just to be able to replicate this data for them to do it, then that's an exception, and it's a reasonable exception that you not do it, and you can go back to just printing and handing them in paper. But if you have the capabilities to comply with that order, it's already stored electronically, then you'll need to do that. Furthermore, disclosures to third parties. If I walk into your practice and I say, please send this to my wife, please send this to my daughter, you need to do that. Please don't have your staff go, oh, well, I don't know if we can do that. You can do that. It can go to the third party designated so long as you've got that in writing from your patient. So put a form in front of them, have them fill out the request for the information, and have them list on there that designated third party. As long as they do that, then you can go ahead and release that to them. We also have a couple miscellaneous provisions, and I'm not going to spend a lot of time on the first one of those provisions, which is compound authorization for research. So anybody in this room who's conducting clinical research, you probably know that in the past you've been getting authorization after authorization for every step of the research process or for multiple research projects that a patient may be going through. I know I'm in a couple clinical studies for diabetes, and I'm sick of signing off on all of the authorizations. You can now do a compounded authorization, and if that applies to you, or you think it applies to you, see me afterwards, and I'll be happy to talk to you about the criteria for determining that. However, the other two are deceased individuals and school disclosures without permission. So family practitioners, pediatricians, you definitely want to listen up for this one. But let's talk about those deceased individuals first off. How many of the medical providers in this room have been in business for more than 50 years? Nobody? Okay, well, then this doesn't necessarily apply to you yet. If your patient has been dead for 50 years or more, it's no longer PHI. After 50 years, the federal government, in its wisdom, has determined that, you know what, nobody probably cares about that, and so we're not going to subject you to the PHI requirements for that individual. If they're dead 49 years and 11 months and a breach occurs, you're in trouble, sorry. Don't ask me how they got to the 50-year rule. I'm still trying to figure that one out. Furthermore, in the terms of a deceased individual, you do have the ability to disclose PHI regarding the deceased individual to family members, other relatives, close personal friends, and persons identified by the individual. But, and here's the caveat, you can only release information to that individual that comports with the level of care they were providing or responsible for that deceased patient. Okay? Obviously, my spouse is the one who my health insurance goes through. She is the ultimate payer. If I were to die on stage this morning, my doctor can release all the information to her because she has the fiduciary responsibilities for the health care. The health insurance policy is in her name through her employer. So as a result, all that information can flow to her. However, in a situation such as we have a gentleman who passes away, has a girlfriend and a wife. You laugh, it happens. The girlfriend wants the information. Well, if the girlfriend's been paying the bills, if the girlfriend's been coming and participating in the treatment of that patient, then there may be an opportunity to share some of that information with her. However, if it's in my situation, the wife covers the insurance, the wife has been there, and the mistress hasn't really ever been known to anybody until now that, Joe has dropped dead, and hello, ladies, meet each other, then girlfriend shouldn't get it, patient should. So just keep in mind, you have the ability to do so, but you do want to follow the trail and find out what was that person's involvement in the care, treatment, or financial remuneration for treatment of that patient, and then legitimate information may flow to them. So moving away from death to kids, so we'll go from one end of the life's continuum to the other end. School notifications. You may disclose PHI without obtaining a HIPAA-compliant authorization to do so to schools about students and prospective students if and only if the PHI is limited to proof of immunization, the school is legally required to obtain such proof of immunization prior to admitting the student, and the covered entity obtains and documents the written and oral agreement from an individual or minor individual's parent or guardian, if applicable. So again, if as a new patient, the parents of your minor patient go ahead and sign consent for medical records, and they give a broad-standing one, and then 6 months later they come in, as I did with my daughter over Christmas when I walked in with the daycare, and approached my pediatrician and said, I need the immunization record sent to the daycare so that we can get her into VPK. They did it. do not need to obtain another signature from me at that point in time specific to that transaction. So you can move ahead with that, and you don't need to get separate authorization if you have standing authorization on hand. However, it would be good for you to take a look at the medical records and make sure your staff didn't miss anything. Make sure you have that standing authorization as part of your patient packet. And if you do, great. If not, well, then I'd probably suggest that you go ahead and have them sign it anyway. And of course, when in doubt, speaking as a soon-to-be lawyer, always better to document. So when in doubt, go ahead and get the authorization. You're not going to get in trouble for getting it, but just understand you don't have to obtain it, especially if you're meeting these conditions. Okay, so covered entities. You guys can sit back. You're now able to go ahead and get your coffee, stretch, take a break, digest what you just heard, recall all the reasons why you hate attorneys and government officials. And I'm going to now talk to the business associates in the room for a few minutes. Earlier this week, one of our MOROF members, Mitchell Gordon, Mitchell, I know I saw you earlier today. There you are in the back. Mitchell made a comment on the open group of LinkedIn that was absolutely very poignant. And he had indicated, talking about this event coming up, he said, there's a new reality, or he referred to a new reality emerging. For business associates in that room, Mitchell is absolutely right. Prior to 2 days ago, there was always the threat that hung over a business associate that, your client can sue you. The doctor's office can sue you if you do something. There's a business associate agreement. We can look back to contract law and enforce it there. But there wasn't really the same teeth, regulatory teeth that applied to covered entities didn't apply to the business associate. Almost 57 hours ago now, that changed for you. Direct liability now extends to business associates. That direct liability, as you're going to see here in a little bit, also means you can be audited by OCR just like a doctor. And if you remember to that opening quote that I gave you from Director Rodriguez, they intend to, quote, vigorously enforce the new provisions of the Omnibus rule with healthcare payers, providers, and their business associates. I did a search on how many times the word business associate and the Omnibus rule have been uttered by a Health and Human Services official in the last 2 months. And I got over 3,900 results. So guess what they're talking about, folks? They're talking about clamping down on business associates. Medical billers in the room, pay attention. You are going to be targeted for audits. Healthcare IT companies who provide services, you too will expect to be in the crosshairs. And Health and Human Services has named both of these business associates by their identification as specifically being targeted in the next few years because of the risks inherent in the type of business that you do. So let's start diving into what happens and what this means for you. First and foremost, we've extended all the HIPAA provisions to business associates and their subcontractors. Okay? So I know IT, so I want to use the IT metaphor, or example rather. The IT company who approaches a medical practice to handle IT for them and says, we're going to do your backup, and then partners with Carbonite, Zenith, any of the other online cloud-based storage providers for their solution. That storage provider has now become a subcontractor of the business associate, and liability attaches to them as well. So for the business associates in the room, you need to take a good, long, hard look over the next 178 days at who are your vendors and where are you going to be able to get a subcontractor agreement in place with them, or at least a letter of understanding or a memorandum of understanding with them that obligates them to it, because keep in mind they're liable as well, and you want to ensure that they're going to be indemnifying you and assuming that liability themselves, so that if the hammer falls on you, you're able to go ahead and address the subcontractor as well. Now, there are some requirements, and it's kind of hard to see because there's a lot of them here. Again, you'll be able to see this online afterwards. But business associates, you can use and disclose PHI only as permitted by your business associate agreement. So covered entities in the room, you have the responsibility to go ahead and draft those business associate agreements. Don't leave them too vague. Make sure you're defining what the scope of the service is to be provided, because the business associate can only disclose up to there. You're expressly prohibited from using or disclosing PHI in a manner that would violate the privacy rule if it was done by a covered entity. So if a covered entity can't use PHI in a certain way, you can't use it in the same in that way either. You're expressly required to use, request, or disclose only the minimum PHI necessary for your business operations under your agreement with the covered entity. You must disclose PHI when it's required by the Secretary for investigation or determining compliance with the privacy rule, and to a covered entity or to an individual in order to satisfy the covered entity's obligation with respect to an individual's request. So again, if you're the medical biller, a patient wants to get a summary of their financial history with the practice and they ask that of the covered entity, you're going to need to go ahead and disclose that back to the covered entity and send that to them so that they can comply with their patient's request. And you're required to take reasonable steps to cure a subcontractor's breach. And keep this in mind. You as the business associate must cure that subcontractor's breach. How do you go about curing that breach? You're not going to do business with them if they don't fix it. Plain and simple. Find another subcontractor to work with. Make sure that they are, and make sure that you're keeping tabs on what they're doing. How are they training? You're obligated to train your staff. Are they obligated to train their staff? What measures are they taking? Obviously, if you're working with very large, reputable companies, chances are you won't have a problem. When you come to some of the smaller vendors, you usually won't find a problem there either because they take this very seriously. It's their livelihood at stake. But you do want to make sure that you're monitoring that, and if there is a problem with a subcontractor, it's your obligation to make sure that it gets fixed. How do we define the business associate? So who's covered under this? Any entity that transmits or needs routine access to PHI. Health insurance organizations, e-prescribing gateways, any of those also apply. Vendors of personal health records who serve covered entities. Subcontractors who create, receive, maintain, or transmit PHI. And entities that, on behalf of the covered entity or organization of care, handle PHI for patient safety activities, are all obligated. Now, there are a couple of exceptions. Healthcare providers who receive PHI from a covered entity for treatment purposes are not business associates. They're healthcare providers. Plan sponsors to group health plans, they are not. Government agencies for purposes of determining government health plan eligibility or enrollment in a plan administered by another agency of the government, and any government entity participating in other healthcare arrangements. There's also what we call the Conduit Exception. And the Conduit Exception has actually been around for a while, so you may be familiar with this one. But the only conduits that are now exempt or not deemed business associates under the Omnibus rules are those that provide transmission services, whether digital or hard copy, including temporary storage of transmitted data. The duration, frequency, and persistent nature of the handling of the PHI is determinative. If you have a conduit who's transmitting data for you on a one-time deal, maybe it's a clinical trial and you're going to go through a gateway that's going to securely transmit the data between you and another entity involved in that research, then it's going to be deemed a conduit and it's not going to be deemed a business associate. However, if you're going to be working with them on an ongoing weekly, monthly basis where they're going to be transmitting it, then they may very well be a business associate. If the entity maintains PHI on more than a temporary basis, then they're not going to qualify as a conduit. So this means a data storage company. So if you back up offline into the cloud, rather, and it's off-site, then you need to know that they are now deemed business associates. You should get that agreement, and they don't qualify as a conduit, where they may have in the past. Moving past this, updated business associate agreements. Those agreements need some provisions in them. We've developed a new template. We've revised the template for the business associate agreement. Anybody wants that, let me know. We'll be happy to get that sent out to you. And that goes for covered entities as well as vendors. Direct liability. We talked about this at the start of this segment of the presentation. Direct liability now attaches, and that means that OCR, the Office of Civil Rights within Health and Human Services, can now audit your business just like they audit the doctor's business. Secretary has full rights to investigate, and those investigations may include reviews of policies and procedures, circumstances of any alleged violations, and they are going to require that business associates must keep records and submit compliance reports as the Secretary deems necessary. Typically, we see that occur when an investigation is launched. and it's going to determine the business associate's compliance with administrative simplification provisions, which means a lot of legalese for you guys need to do a risk assessment and make sure you have one on file, just like the medical practices. And you must comply with the Secretary's complaint investigation and compliance reviews the same way the doctors do. Bottom line, Congress gave Health and Human Services, and more specifically the Office of Civil Rights, the ability to exert that power, and the Omnibus rule has now exerted that authority. So understand you now fall under the same provisions that the doctors do. And I'm seeing one of my client nurse office managers over there starting to smile a little. So civil monetary policies, guess what? They apply to you as well. And there is the chain where multiple covered entities or business associates have violated the provisions of the Omnibus rule or of HIPAA in general. They can go after penalties for each violator. So doctor and business associate can now both be penalized, whereas before it was really the doctor shouldered all the responsibility. Now they can find the doctor, they can find the vendor. Oh, and vendors, if you and your subcontractor breached it, they can find you and the subcontractor. So just know they can go after multiple parties at this point. And liability does attach in accordance with federal common law of agency to a covered entity for violations of its business associates. So doctors in the room, guess what? The law of agency says there is an agency relationship between you and your business associates, and liability can attach to you. So unfortunately, I'm sorry. I know, Martha, you were starting to smile there a minute ago, but unfortunately, hate to tell you, we can still come after you too. Martha's being so nice to let me pick on her this morning. So here's what we want to know in the last few minutes. How do I comply? What do I need to do? Well, first thing everybody in the room needs to understand the compliance date. September 23rd this year, 178 days from today. Please keep that in mind. That is the compliance date. Future standards that get announced moving forward will have a 180-day compliance date. That's been set forth. So we at least now have a definitive rule, until they change the rule, that says you'll get 180 days notice on future standards. Business associate and data use agreements, they have a transitional compliance schedule. And we're going to talk about that real quick. Generally, all business associate agreements now need to be compliant with the new requirements by September 23rd. However, if it has been renewed or modified on or after March 26th, 2 days ago, then you may not have to, and if it was entered into originally before January 25th of 2013 and was already compliant under old standards, you actually get until September 22nd of next year for that business associate agreement to be amended. So there is a transitional. You have questions on that, I'd be happy to walk you through that. It's basically going to mean just pulling off, dusting off, taking a look at your agreements. Bottom line, if it was in force, if it was first enacted before January 25th of this year, it's HIPAA compliant, it's modified somewhere between now and September 23rd, then you get till next year to have to make the new requirements because it's deemed a new business associate agreement. You got to have some time under the original bargaining power. If that business associate agreement is older than January 25th of this year, then it needs to comply by September 23rd. Covered entities, what do you need to do? One, review the contracts with your business associates and contractors for the security assurances, update those. Establish reporting mechanisms for PHI security breaches if you don't already. Make sure you review your notice of privacy practices. Those will need to be remailed before September 23rd. You want to understand when and how to conduct a risk assessment. We're going to touch on that real briefly in a second. And you want to revise and redistribute your privacy practice. Business associates, guess what? You need to conduct a risk assessment as well. And they need to be looking at identifying any vulnerabilities in your practice as it pertains to healthcare. If you're a vendor and you service multiple industries, the risk assessment is only going to look at the healthcare portion of your business, not have to look at the rest of it. If you are a medical billing company, guess what? Congratulations. You're all looking at Louie in the back. Louie, guess what? Your business needs that risk assessment for the whole business entity. Computech City, we're in the same boat. We've got to see it on the IT and on the billing side as well. So those risk assessments need to be done. You need to develop and implement your HIPAA training programs for your staff. Review compliance with your subcontractors and develop your required policies. There are 3 policies in particular you should have: a privacy, a security, and a breach incident response. I'll be happy to give you templates that you can use then in discussions with your attorneys on how to develop those. So last, I want to have a word on risk assessments. Last week, the Office of Civil Rights put out its study. If you recall, last year they did these random HIPAA audits on a test basis. And after they completed those audits, they went back and they studied them. And they got survey feedback from the participants. Imagine being a participant. You're a doctor who got a surprise HIPAA audit, only to then get a customer satisfaction survey. I can only imagine the comments that flew in that doctor's office when they got that request for a customer, and it was labeled a customer satisfaction survey. So the results of the survey and the internal audits revealed that 80% of physicians audited in 2012 did not conduct a risk assessment. They flatly don't have one on file. They cannot produce one. 2/3 of those that did have risk assessments, so 2/3 of the 20%, were determined shallow and not conforming to federal guidance. I've got an example for you for what they mean by shallow. This is a risk assessment performed by an entity for a doctor. This is another risk assessment for that very same medical practice. There's a big difference in terms of the risk assessment. Just using checklists, the do-it-yourself kits, or I'm going to go online and find the 5-question checklist, and if I just check it off, I'm good, it doesn't count. This is 41 pages, and one of those 41s is the facts cover sheet to me. This is just over 220 pages. So make sure that when you're doing it, you're taking the time to go ahead and do a risk assessment properly, because, again, HIPAA mandates that you do them. There's the biggest misnomer is that, meaningful use requires it. If I don't doing meaningful use, I don't have to do a risk assessment. No, actually, HIPAA says you're supposed to be doing one every year. The reason why it's included in meaningful use is the fact that we know that 80% of doctors aren't doing it. So we said if you want federal money, you got to start doing a risk assessment. So make sure you do those risk assessments. Do them properly. I know I hear it all day, every day when I'm talking with doctors about this. It costs money. I don't want to spend that money. Well, folks, we've talked a lot today about what can happen. Remember that nurse manager who lost that laptop somewhere between the gym, Walgreens, and her house? I guarantee you that medical practice is paying out a lot more than the couple $1,000s it takes to do a risk assessment. Had they done a risk assessment, we would have been able to identify the fact that your laptops are unsecured, you don't have the ability to wipe them, there may be other factors we need to address, and none of that was taken into account. They didn't go ahead and fix it. They never even thought about it. I mean, the comment from the office manager and the doctor both were, we never thought about this. Had you done a risk assessment and paid a couple $1,000s to a company who would do that, then at least you'd have that peace of mind knowing, okay, we know what we need to fix, we know where our risks are, and let's go ahead and do it. Because ultimately, at the end of the day, this is your business. You've put a lot of time into it. Business associates, doctors alike. Don't risk it unnecessarily. We have these rules here because we want to protect the patient. We also want to protect you. Any good risk manager in healthcare will tell you that if you have an effective, robust risk management program, you will benefit from it. Your business will thrive. We have an insurance agent who provides professional insurance to the healthcare community. And Vicky, tell me if I'm wrong on this, but you would much prefer to see a doctor who is compliant, has risk management procedures in place for their practice, because it lowers your carrier's risk as well. You may also find, this is not always the case, but I have heard of several practices who have said having the risk assessment in place, being able to show their insurance carrier that they've got it and that they're taking the steps. Several have been reporting that they have actually seen discounts and reductions in the premiums that they pay. And again, I'm getting a nod from Vicky on that. So keep in mind, there may be a financial payoff for you as well. Lastly, I thought I would close with another comment from Director Rodriguez, and this one came out just March 21st, a few days ago, when he said, we will have a robust program, meaning an enforcement program, focused on high-risk areas, and one thing they, covered entities and business associates, can absolutely count on is the risk analysis. So guess what? If they come knocking on your door, they're going to want to see this or this. Make sure you have it, because doing that is the first step to making sure that you're meeting the requirements that you need to have in place to protect your patients as well as protect your practice. And with that said, I know I'm over time. I'm sorry. Any questions anybody has? And again, if you don't want to ask them now, I will stick around after the presentation. I know some people need to scoot. So if you need to scoot, I'll have my contact details, so we'll get in touch with you. But if you have questions, I'm happy to answer them now or even after the
I have one question. Could you do a little bit of clarity on when the patient is paying for the medical services themselves and the fact that you're not allowed to disclose that health information if they ask you not to?
Absolutely. On that, provided the practice, if it is completely paid for by the patient from start to finish, and they ask you not to disclose that information to the payer, and it is not otherwise required to be submitted to the payer, then you do not release that information consistent with their request. So the patient has the ability to say, I don't want this information shared with my health insurance provider, in which case then you have to. But again, the requirement on that is that that it is not required, all right, and that it is fully 100% paid for. If that insurance payer has to pay it, or if it's subject to a deductible, out-of-pocket maximum, subject to copay, any of those trigger events, the insurance company has the right and you have the obligation to provide that information to them. However, if it is purely a cash basis payment, it is not something that is flowing through and it is not required to be disclosed, then they have the ability to go ahead and request that. Does that help? Yeah, I have a lot of suspicions on my own self as to why that is. Not a whole lot of clarity in terms of why Health and Human Services has put out. Let's put it this way: they haven't come forth and stated as of yet why they did. I looked back on that provision and looked through the rulemaking comment on it, and surprisingly, it was floated in the interim rule. It stayed in the final rule with very little modification, and because they didn't do anything but some cosmetic modifications to the language and correcting a spelling error in that particular provision, they're actually not obligated to go ahead and indicate why they chose that rule. So I got to scratch my head as well on that one. There may be attorneys who are far better at this than I am who would know that, but I don't, unfortunately.
I have a question about the email. We have patients sometimes that want to get an email as far as a statement so they can pay it.
Yep.
Is that HIPAA compliant as far as what kind of email we'll be sending patients?
The HIPAA compliance on the email is going to trigger off of what kind of an email platform are you using, and is that data being transmitted encrypted or otherwise secured. The movement is towards encryption. So you want to make sure that you're using a secure email platform to transmit to them. Obviously, if the patient says, email me at my Gmail account, and that's the destination for that email, you're not obligated on that end. But the question becomes, what are you sending it from? If you're sending it from mybillingcompany@gmail.com, then yes, you have a problem, because that is not a HIPAA compliant email platform. If you're using a product like Microsoft Office 365 or Microsoft 365 or some of the others that are out there, to which there are a number of them, those are fine. There are even services now where you're going to send that email and it uploads to a server, gets encrypted, and then sends a message to the recipient saying, hey, you're not in my database, so I'm not going to unencrypt this email. You validate who you are, sign in here, and then you can view the email. Once they do that once, now they're stored in there, and all future emails from you to that patient will now go straight through because they are associated with an encryption key that will go ahead and unencrypt it when they open that email. So there are a number of different options, and I'd be happy to share them with you.
All right, we only have time for one more question. Does anybody else have a question? Because we're pushing 9 o'clock.
Hey, Keith.
Hey.
I have a question about the subcontractor and the business agreement.
Yeah.
So you have the main business agreement, and then are we also then responsible for the business's subcontractor? Is that all covered under one, or?
No, it is not. What happens is the business associate agreement exists between the covered entity and the business associate. However, all the terms and provisions of that business associate agreement apply to any agreement between the business associate and the subcontractor. What we have done is we have shifted the burden for subcontractors off of the doctor and put it squarely on the vendor. And it is up to that vendor to ensure the compliance with it. Now, if there is a breach at the subcontractor level, we're going to look back to the vendor and not to the doctor first. So they have to, but the long answer to your very short question is the business associate agreement governs the relationship between the business associate and the subcontractor. And those terms apply to them whether they have an agreement or not. So if they don't enter into a formal agreement that reiterates those same provisions, they don't. I do know business associates are going, you know what, I want to take that business associate agreement and I'm going to just modify it and call it a subcontractor agreement and I'm going to use it there. And unless the vendors or the business associate's attorney has other provisions, I would say that that's probably a good thing. But again, consult with your business attorney and they'll tell you how they'd prefer you to handle that.
Thank you for all your questions. Let's give a round of applause for Keith Carrington.
Thanks for coming out. Oh, Michelle?
Yeah.
One last comment, and I'm sorry. Folks, this will be online. This video will be online. Should be online no more than a week. I think it may even be out there earlier. We will let you know when it happens. We're also going to be taking this discussion online, and it's going to be going to the open group on LinkedIn for MOROF. So if you're on LinkedIn, consider joining that group or look for it. It's MOROF, M-O-R-O-F. It's the open group. We're going to continue the discussion there. So general questions that you have, feel free to pop them there. I'll be answering those over the next several weeks as well.
And that's the best part of this, because all of the practice administrators here, we know that not everybody could come to these meetings, but the conversation, as Keith said, always continues online, and we have multiple meetings that are online too, so make sure that you tap into all of the topics that are offered on the MOROF LinkedIn page. If you would like to come back for our next meeting, we do one every single month, as I said when we started off this morning. It is the last Thursday of the month. In April, we're going to be talking about the ever-changing healthcare reform. I know, it's exhausting. So that's the topic of conversation for next Thursday. We thank you so much for being here.